Hi, my name is Tambry Bradford, and I'm a litigation partner with Pepper Hamilton in Los Angeles, California. I want to welcome you to the fourth series of podcasts that the law firms of Troutman Sanders and Pepper Hamilton will be producing over the next few weeks. These podcasts will discuss litigation topics that have been brought to the forefront by the COVID-19 pandemic and how businesses might be able to prepare and respond. Today's podcast is going to focus on regulatory takings and executive power to seize property during the COVID-19 crisis, focusing on business closure orders and other orders of state and local governments. We will first discuss a broad overview of takings and how to explain these concepts in an understandable way to a business team. Second, we will look at where these issues have been recently raised and addressed by courts. Third, we will consider practical ways to address these issues. And finally, we will discuss questions clients are raising regarding specific government orders to identify and, in some cases, commandeer supplies. Our panel today consists of Ashley Taylor, a government regulatory partner in Troutman Sanders' Richmond, Virginia office, Christopher Browning, a litigation partner in Troutman Sanders' Raleigh, North Carolina office, and Michael Hino and Justin Weber, litigation partners in Pepper Hamilton's Berwyn and Harrisburg, Pennsylvania offices, respectively. Each of our panelists has extensive experience representing clients in complex litigation and challenges to government authority, and in recent weeks have been advising clients on governmental issues stemming from the COVID-19 crisis. My first question is for Ashley. Ashley, I know that you deal with constitutional issues on a regular basis in your practice. How do you go about explaining these very nuanced constitutional takings claims to a CEO who is not a lawyer?
Well, Tambry, the first thing we try to do to ensure a better understanding of these issues is to find an example that everyone can follow. And in this current crisis, I would use as an example scenarios centered around a restaurant. And the taking concept would arise in one of five ways. First, it could arise as a traditional taking issue. That is, the government takes property and appropriates it for the use of the government. For example, the state seizes a restaurant and the restaurant's food supplies to feed first responders. That would be a traditional taking that must be compensated under the Constitution. The takings claim would include the food being seized and the use of the building for the duration of the seizure. Second scenario would involve the state's using of its police powers. And under its police powers, states may adopt reasonable restrictions on private property. In this hypothetical, customers at a specific restaurant may contract the COVID-19 virus, and the state concludes that because the food supply at the restaurant has been contaminated with the virus, it must be destroyed. And it therefore issues an order compelling the destruction of the food, and that would not be compensable. In this case, the government is seeking the use of the food to destroy that needs to be destroyed in order to protect the public health. The third example relates to the Contracts Clause, in which the United States Constitution bars states from impairing the obligations of contracts. In that example, if a restaurant entered into a binding contract to sell its non-perishable food to an online retailer, and the states were to subsequently bar all bulk foods, that could implicate the Contracts Clause. Another example, and it's one that people probably think about in this context, is a partial regulatory taking. This is an example that may regularly occur and often will occur in the context of the COVID virus. An example would involve an executive order that requires the restaurant to close or to only provide takeout food. These types of partial regulatory takings are the cases we are most likely to litigate in this environment, and this is the closest to what a CEO is likely to face. What others may discuss, but is not very likely, is a complete regulatory taking. In that case, a state were to enact some zoning or legislation making all restaurants unlawful, depriving the property owner of all of the economic benefit. This is more of a law school example than something we are likely to face as a result of the virus. So, Tamara, that's how I would try to explain the 5 scenarios to a CEO in a way that could be useful.
Thank you, Ashley. Let's turn to Justin. Justin, many questions are being raised regarding governmental authority and the regulatory takings that Ashley has just explained to us. Can you give us an overview of the litigation landscape and any recent decisions with respect to these issues?
Sure. Thanks, Tambry. We are monitoring a couple of cases that have been filed around the country that involve the partial regulatory taking or the regulatory taking that Ashley mentioned. There have been cases filed in Colorado, in Connecticut, and also Pennsylvania in the last several weeks, asserting claims based on business closure orders and asserting that those business closure orders result in a regulatory taking. Of those cases, probably one of the broadest and clearest challenges is a purported class action that was filed in the Eastern District of Pennsylvania against the governor of Pennsylvania and the Secretary of Health. The suit alleges that the governor's order closing non-life-sustaining businesses is a regulatory taking that requires compensation under the Fifth Amendment. Now, the case hasn't proceeded past the pleading stage, but a broad challenge to a closure order like that, like the class action, is going to have a number of challenges. As Ashley mentioned, regulatory takings cases are highly fact-specific, and I think a recent case issued just this week on April 13th by the Pennsylvania Supreme Court highlights that aspect. On April 13th, the Pennsylvania Supreme Court exercised its King's Bench jurisdiction and decided a case involving the governor's authority to close businesses and a claim that resulted in a regulatory taking. The case is Friends of Danny DeVito versus Wolf, and it's likely to be cited by other courts because, to my knowledge, it's the first appellate decision issued in the COVID crisis on this issue. A few highlights from that case. First, the court found that the COVID-19 pandemic is a natural disaster within the meaning of Pennsylvania's emergency code, and no surprise, the governor has authority to exercise and properly exercise that under the Pennsylvania Constitution and statutory authority. Number two, with respect to the regulatory taking claim, the plaintiffs asserted that compensation was required under both the Pennsylvania Constitution and the federal Constitution because of the complete cessation of their business. The court rejected that argument. It rejected it primarily for two reasons. One, it focused on the governor's closure of businesses to protect the health and safety of the citizens of the Commonwealth and held that that was a classic example of an exercise of the police power. But more importantly, it held that the governor's order was only temporary and that because it was a temporary order, it did not result in a regulatory taking. Now, the case wasn't without a dissent. The Chief Justice concurred and dissented. And importantly, the Chief Justice said that this is a highly fact-specific issue, and he would have allowed the case to have further factual development rather than addressing the issue on the King's Bench jurisdiction. So I think that there are two takeaways from this first appellate decision regarding a regulatory taking, perhaps one legal and one practical. First, as we already mentioned, these are going to be highly fact-specific challenges. The more compelling the factual pattern, the more likely the case is to succeed. Here, where the emergency is extreme, there's going to be broad deference granted to the governmental authority, but where the facts in your case are significant and extreme, it's more likely to have success on the takings argument. The second takeaway, and I think Chris is going to talk about this, is in the midst of needing immediate relief, what are other efficient and practical ways that you may be able to explore to mitigate or obtain relief from the effect of a closure order?
Thank you, Justin. You've led us right into my question for Chris, which is, How have you seen these constitutional issues play out on the ground during the COVID-19 crisis?
Well, these orders, by necessity, are implemented on an expedited basis with very little opportunity for full impact by the stakeholders. And as a result, several of these executive orders really have, despite the best efforts of the government to write these orders on a short time frame, you can see unintended consequences that are set out in these orders. And these unintended consequences can really be compounded by the fact that often you have a series of changing orders. Sometimes you have a situation where you have different branches of government addressing aspects of their branch, but that inevitably overlaps with other executive orders. You also have multiple agencies from time to time addressing the same or similar issues. What I would urge clients to consider as they're faced with these situations is to promptly reach out, open the lines of communications with the governmental officials that have promulgated that order. And in doing so, I would strongly suggest that you use concrete examples of some of these unintended consequences of these orders and how to achieve a better outcome that is still consistent with the government's intention, but doesn't have the adverse effect on businesses and our communities. Essentially, when you're reaching out to governmental officials to try to effectuate some sort of change or revision to an executive order, your goal really should be twofold. First is to get the executive branch to revise the order to minimize these unintended consequences and its impact on businesses, employees, and our communities. The other thing that you want to focus on, the second goal, is to really develop a record if a lawsuit is necessary. Ultimately, the court will have to be deciding whether a state's exercise of the police power was reasonably necessary to achieve the government's purpose. So you want to build that record as to why the government's action really wasn't reasonably necessary under the circumstances. It had gone too far and should be scaled back. Frequently, it goes too far because the government's order has certain unintended consequences that just can't be fleshed out in the speed in which these orders are, by necessity, having to come out from state and local government. And our experience since this pandemic began is that most governmental entities are willing to address these unintended consequences. And that makes a lot of sense because here, businesses, the community, and government are generally aligned on these sort of issues. Everyone wants to, has a very strong interest in protecting the public health, protecting customers, protecting employees, and not putting more people at risk. But there's also a strong interest in not destroying the industries that are really part of the backbone of our nation's economy, many of whom are seeing great difficulty during the current COVID-19 crisis. And really, my practical advice here is that when you're faced with an executive order that has unintended consequences, I would urge clients to make sure you open the lines of communication with governmental officials very early and maintain a transparent relationship so they can understand and see what's really happening on the ground as a result of these executive orders. I'd also recommend that when you're communicating with governmental officials, you be very precise and as specific as possible. As I said earlier, give government officials concrete examples that they can work with and that they can appreciate the plight that your client is in. And you also have to recognize that governmental officials, as you would expect, are under a tremendous amount of pressure, and there simply is a great demand on their time. So you want to be clear, concise, and provide them with the information that they can then act upon. I would also make sure that you explain the ramification of these unintended consequences. There is a reason that they're unintended, because at the time the order was drafted, someone didn't appreciate or understand how a particular industry sector operates, and you need that understanding to minimize and mitigate the effect that some of these orders have on our economy. And we have seen that with multiple clients, that a order is issued, it has a dramatic impact on a client that isn't appreciated at the time that that executive order is signed. But by bringing this issue to the attention of the governmental officials, you can work together to try to obtain a revised order that really works better for the community, the government, and businesses. I would also recommend that you provide specifically for the governmental official the language that you propose to be changed and how it might be changed. Additionally, if you're not getting any traction with that initial outreach, you really need to evaluate, in an appropriate circumstance, a public relations strategy, if that's what it's going to take to move the needle that your company doesn't go out of business as a result of a particular executive order. And also prepare a litigation strategy if necessary. And you also want to emphasize, or have your client emphasize to governmental officials, that they are there to be part of the solution, and they are willing to work with government to obtain a result that's right for everyone. And lastly, and I just saw this on my own part a few days ago, as the attorney, don't hesitate to beg and plead that this is the time that attorneys need to be pulling out everything in their arsenal to try to get the attention of governmental officials if there is an unintended consequence that potentially could drive your client out of business. This is the time that you do your absolute best to help these clients, that many of whom are facing horrendous circumstances for keeping their business open. In short, urge your clients to work with regulators from the outset and make sure that they provide you with the information that you need to work with governmental officials to craft appropriate orders to address this crisis. That's what we have seen in our work so far over the last 3 or 4 weeks, in many circumstances with many different clients. And that's the practical advice that I would give based upon what's happening on the ground right now.
All right. My next question is for Mike. Mike, many states are issuing orders requiring the identification and reporting of supplies of personal protective equipment. In some cases, these orders authorize the government to acquire the PPE. Can you describe some of the issues that are being raised regarding these orders?
Thanks, Tambry. I want to talk quickly about 3 issues that have arisen. First, and this will touch on what my colleagues have talked about, what's the authority for these orders? Second, what's the scope? And then third, some of the compensation issues that might arise from these orders. Regarding authority, as Ashley mentioned, state constitutions allow the taking of private property for the public good. So most of these orders start from the Constitution. As Justin mentioned, in Pennsylvania, as an example, we have an Emergency Management Services Code, which is a state statute that allows potentially taking of goods And then, as Chris mentioned, there are often you get into municipalities have their own laws. Hopefully, as Chris mentioned, there aren't unintended consequences and they don't conflict with each other, but that's the authority. In terms of the scope, there's a couple issues. First, geographic. Most of these orders, you would think that the state only has the ability to gain and acquire goods that are in their particular state. What would be interesting is if a state tried to get goods, if the headquarters, as an example, were in one state and the warehouse was just over the river in another state, would they be able to get those goods? I don't think they'd be able to seize them, but that would be an issue. A second issue that comes up is who, if anybody, is exempt from the issue. As an example, should a hospital, if they're required to give up some of their personal protective equipment, who should be making the decision as to whether or not that hospital has sufficient personal protective equipment? And then the final issue I just want to touch on is compensation. Anytime the government's taking your property, you're entitled to be compensated. States we've seen have done it in different ways. As an example, one state has a board of 3 people that decide what you'll be compensated for your goods that are taken. Other states, hey, if we can reach an agreement, great, that's what you'll be paid. Pennsylvania actually has something interesting where they say that you'll be paid the price for the goods during the 7 days immediately prior to March 6th of 2020, which is when a lot of the issues regarding the pandemic started. March 6th was 40 days ago. Prices change with supply and demand, and one of the constants in this crisis has been how quickly things change. So what was a fair price 40 days ago may not be a fair price now. So I expect that if we're going to see litigation, it may be related to that. In some, it'll be interesting to see how issues play out. I think whether we see litigation regarding these issues, it'll depend upon how long the pandemic lasts. It appears that the private sector and volunteers have stepped up. Personal protective equipment, we've seen a lot of folks. Ford, as an example, is making it. A lot of volunteers are making it. So who knows? Maybe the need to seize these materials will pass. Every day is a new day as we learn more about the virus, how it's transmitted, who it impacts, potential tests and cures. There have been a lot of twists and turns, and I expect more.
Thank you, Mike. I have a final question that I'd like to pose to all of the panelists. What do you expect to see on the horizon regarding takings and executive power? Why don't we start with Ashley?
I expect that there will be a number of follow-up investigations from companies who were aggressively flouting the rules regarding both limitations in supplies and companies that are entering into contracts to provide services for the government that are not familiar with governmental contracting rules. I expect there to be a significant amount of fallout. Initially, the government will focus on the traditional scammers, the individual who rents an RV or a large truck, goes to Dollar General, buys all the hand sanitizer, and then marks up that hand sanitizer as he drives up and down the street. But the second wave I expect to be against those companies that are more traditional companies who were trying to react to the crisis, whether it was banks, medical supply companies, brokers, etc. I expect there to be a lot of fallout. There is always fallout anytime the government pushes a lot of money out the door, particularly in Washington, as everybody tries to figure out the rules as they go along.
Justin, what are your thoughts?
So one thing that I think will be interesting is to watch how the development of the case law on the regulatory takings front takes shape. Certainly, we haven't had a pandemic in a long time, and I think it's going to provide an opportunity to further flesh out and define the case law in that space. I also think it, as Mike said, is going to be contingent on how long a lot of the business closure orders exist and how long they are still in effect. If they're still in effect in June, I think things look a lot different than if they end at the beginning of May. It goes back to that fact-specific inquiry, and I think we're going to have some new or fleshed out guidance consistent with the Fifth Amendment and other state constitutional provisions. And for litigators, I think that will provide interesting arguments and also interesting cases to follow.
Chris, what are your expectations?
Well, I guess there are a couple of different fronts that come to my mind. The first one being the litigation front, as people have mentioned. And I think, people who have listened to this podcast so far get a sense that unless there is a physical taking of property, as Ashley mentioned, for use by the government, if we're just talking about a regulatory taking, unless you're in a state that really seems to embrace that doctrine, most of the case law is not extremely favorable. It is a facts specific situation. So I think we'll see some companies having to fight this out as a last resort in some jurisdictions, but it is not litigation that really anyone should go into lightly. So I'm not sure that we'll necessarily see a huge growth in litigation on the regulatory takings front subsequent to the pandemic, but a lot of that depends, as people have mentioned, how long this lasts, to what extent are governmental entities having to become more and more assertive to try to put this pandemic behind us. So there's a lot that we just can't tell sitting here in mid-April discussing this particular issue. Again, if somebody is anticipating litigation, make sure that you are only litigating a case where the facts really work in your favor, because it is fact specific. It is a hard argument in some jurisdictions to make, and do make sure you develop that record at the outset. So in short, my prediction, for what it's worth, is that we will see some additional litigation under the takings clause after courts reopen as a result of this pandemic. But I don't think it will be as many as some of us might predict, unless this really does go on for many, many more months. The other thing that I would suggest as clients are evaluating what to do, you really need to be mindful of the public relations front. That, right now, as of today, we're basically looking at 700,000 cases of COVID-19 in the United States and 35,000 deaths so far. If those numbers continue to steadily increase or exponentially increase, and the deaths further expand, any client needs to go in well aware of the public relations impact that they might have down the road if they are perceived as not doing the right thing during this time of crisis. So you really need a business to be carefully evaluating many more factors than you typically would with any other litigation. And I think even though this only has an indirect impact on litigation, but there will clearly be a political front as a result of all this. It will probably be the centerpiece of our next election. We have certainly seen that in North Carolina, where back in mid-March, the lieutenant governor who is running against the governor criticized the governor for issuing executive orders. Those political issues, as they become part of the November campaign, will greatly impact the public's view, greatly impact how the courts view this, and will greatly impact whether clients should be trying to get these disputes in court or trying to avoid them at all costs. So to me, those are the three fronts that I see: litigation, political, and public relations for clients.
We'll end with Mike. Mike, what do you see on the horizon?
Just to echo what my colleagues have said, to be brief. One, I think it depends how long this goes on. If it goes on for a long time, we'll see much more litigation. If it ends soon, I don't think we'll see that much. Chris made a good point about public relations. It'll be interesting to see how this plays out and how it could play out in a courtroom. Generally, when you try an eminent domain case as an example, everybody has a visceral reaction to the government taking their property. Here, if somebody is standing up and being opposed to the government when maybe the public thinks that they should be cooperating more, they may not be seen as the good guy, so to speak, in litigation. So I think a lot will depend on how long it goes, and as Chris said, what the public relations are, how the parties are viewed when they ultimately bring suit, and if they need to figure that out before they decide to bring a suit.
Thank you to Ashley, Justin, Chris, and Mike for offering your insights today. If you have further questions, please feel free to contact any one of us or visit our COVID-19 Resource Center at covid19.pepperlaw.com.